Good morning. This is the time and place for the Maryland Public Service Commission's administrative meeting. Before we get started today, we have a few personnel announcements. I'd like to recognize Lloyd Spivak, who's a constant presence in this hearing room. Lloyd doesn't know this, but we're kindred spirits of some respect. Both of us have done a significant amount of time in upstate New York at the SUNY Institution. That's not a penal institution, but we also both went to American University and are alum of the Department of Justice. Lloyd's been with us now for almost 20 years at the PSC. He's done great work, and I'm pleasure to announce today that he will assume the position of Deputy Staff Counsel. So please join me in congratulating Lloyd. Thank you. And Commissioner Richard recently had a new employee join his personal staff.
Yes, thank you very much, and I'm excited to welcome Megan Case. You see, I always have this iPad here, and for the most part, I can quickly pull up documents, but at this point, I don't have the resume in front. But she comes to us most recently from the governor's office and had did a lot of support on the second floor, and I'm very excited that she'll be here. As you may know, Matthew Goldberg went off to law school, and so he will be missed, but I'm very pleased to welcome Megan, and we look forward to work with her. So why don't you stand up again so everyone gets to know. Okay, thanks.
Without further ado, we have our minutes from the August 15th administrative meeting. Is there a motion to approve them?
Yes, I move that we approve the minutes from last week's administrative meeting.
All in favor, please say aye.
Aye.
The minutes are approved. Madam Secretary, can we move to the consent agenda?
Yes, Mr. Chairman. There's only one item on the consent agenda. It is Delmarva Power and Light Company, Potomac Electric Power Company, filed on July 12, 2018, designation of weather stations in compliance with COMAR 2031-0305.
Thank you. All in favor, please say aye.
Aye.
Any opposed? The consent item is approved. Madam Secretary, can we move to the administrative agenda?
Yes, Mr. Chairman. The second item on the meeting and the administrative agenda is Broadview Networks, Inc., filed on August 2, 2018, notice of detariffing of all retail services pursuant to order number 88353, case number 9414.
Thank you. And if there are any external parties today that wish to speak on matters that staff counsel are speaking on, if you could please approach the bench when your item is called. Thank you. Good morning.
Good morning, Mr. Chairman, Commissioners. Kenneth Albert on behalf of staff. This item addresses a filing by a telecommunications company, Broadview Networks, that asks the Commission for authorization to withdraw their tariff for local exchange service and for inter-exchange service, which is a long-distance service. Elimination of the inter-exchange service is consistent with the law passed by the legislature in 2015 that deregulates inter-exchange service. Detariffing of the local exchange service is allowed by the Commission's August 2017 decision pursuant to the same law that determined that a competitive local exchange carrier, CLEC, with a 20,000 customers or fewer can detariff its retail local exchange services. Therefore, staff recommends that the Commission authorize Broadview to withdraw its tariff for local exchange service and inter-exchange service.
Thank you. Are there any questions? Thank you, Mr. Albert. Is there a motion?
Yes, Mr. Chairman. I move we accept the company's request to detariff its regulated local exchange services and note the withdrawal of the company's IXC tariff.
All in favor of the motion, please say aye.
Aye. Second.
Aye.
Any opposed? The motion passes. Madam Secretary, the next item, please.
Item number 3 is Matrix Telecom, Inc., DBA Matrix Business Technologies, also DBA Trensic Communications, filed on July 24, 2018, notification of company name change and replacement tariffs.
Good morning, Chairman, Commissioners. Janice Flynn for item number 3. Matrix Telecom is updating the name on its tariff pages to reflect the conversion of the company from a corporation to a limited liability company. Although this change in corporate form took place in 2015, and the company registered its name with the Maryland State Department of Assessments and Taxation in February 2016, the company failed to reflect the name change in its tariff. This filing updates the tariff to reflect the correct corporate form. The change has no impact on customers, as there will be no change in the name of the provider and no change in the rates, terms, or conditions of service. No customer notice is necessary, therefore, and the company also has no outstanding assessments. Staff recommends that the Commission accept the tariff for filing with an effective date of August 23rd, 2018, which is what is noted in the tariff.
Thank you, Ms. Flynn. Are there any questions? Is there a motion?
Mr. Chairman, I move the Commission accept the tariff pages for filing with an effective date of August 23rd, 2018.
Is there a second?
Second.
All in favor, please say aye.
Aye.
Any opposed? The motion passes. Thank you.
Item number 4 is Converge, Inc., filed on June 18, 2018. Request for name change to Itron Distributed Energy Management, Inc.
Good morning, Commissioners. Chairman Michael Dean on behalf of the staff. Item 4 is a notice filed by curtailment supplier Converge, Inc., that its parent Peak Intermediate Holding LLC merged into Converge and then immediately merged with Itron DR/EE Inc. to form Itron Distributed Energy Management Inc., which was then merged into the surviving company Itron Inc. Under COMAR 20.51.03.01D, a licensed supplier shall provide any additional information as may be required by the Commission, and the letter order approving the license reminded the company of its obligations to inform the Commission of any substantial changes to the information contained in its application. Staff reviewed the filing and also reviewed the status of the companies with OER and SDAT. Staff recommends that the Commission note the mergers and change the name on the company's supplier license IR 2860 to Itron Inc.
Thank you, Mr. Dean. Are there any questions? Is there a motion?
Yes, Mr. Chairman. Yes, Mr. Chairman, for item number 4, I move we note the mergers and change the name on the company's license IR-2860 to Itron Inc.
Is there a second?
Second.
All in favor?
Aye.
Any opposed? The motion is approved. Thank you.
Thank you.
The next item, item number 5, ebullience, is being deferred to a future admin meeting. Item number 6 is Hyco Energy LLC and Major Energy Electric Services LLC, filed on July 31, 2018, a joint notice of an assignment of customer contracts from Hyco to Major.
Michael Dean again on behalf of staff. Item 6 is a notice jointly filed by Hyco Energy LLC and Major Energy Electric Services LLC for the assignment of 11 customer contracts from Hyco to Major. Under COMAR 20.53.07.12, customers are to be notified at least 30 days prior to the effective date of any assignment or transfer of supplier contracts to another supplier. Staff notes that Major has been the subject of a Commission enforcement action in 2016 in case number 9346B and was assessed a $250,000 civil penalty for misleading marketing in unauthorized service territories and a $50,000 civil penalty for violating contractual requirements of the Maryland Door-to-Door Solicitation Act. Order number 87418 of February 26, 2016 assessed a moratorium on marketing by Major until it had revised its sales agreement and provided the agreement and marketing materials and sales script to OPC and staff, but the company was not required to seek OPC or staff concurrence that these materials were compliant or seek Commission approval to lift the marketing moratorium. Staff has reviewed the filing and determined that customers received sufficient notice of the assignment of contracts. As noted in staff comments, staff reviewed with OER the complaint history and with the fiscal division the assessment status, and was informed that Major has one open complaint. Staff recommends that the Commission note the filing.
Thank you, Mr. Dean. I was just curious. I note that there's only 11 residential customers that will be affected and transferred in this matter. The application did not state so, but do you have any idea of why this transfer of these 11 customers are occurring?
Good morning, Chairman and Commissioners. Matt Bonikowski for staff. So this is following acquisition of HEICO by Major. HEICO's customers are being transferred over to Major. The current plan is for HEICO to retain its license but not to actively seek new customers at this time. And as I understand it, once all the customers has been transferred over, HEICO is planning to come in and cancel its license.
That makes a lot of sense. Thank you.
Quick question.
Commissioner O'Donnell.
Thank you, Mr. Chairman. I wanted to ask staff about the outstanding slamming complaint against Major in light of the fact that this commission has issued significant civil enforcement against Major in the past for poor marketing practices, fairly substantial, $250,000 and $50,000 respectively. What is the nature of the outstanding slamming complaint against Major?
I don't have any other details beyond the fact that it was for slamming. We could certainly check with OER and provide details on that.
Do we know when it was filed? Is it recent? Is it old?
It is a recent complaint. It's still open. I believe we checked the past 6 months, but the complaint is still open at this time as far as I'm aware.
One would think that there wouldn't be such complaints, and not that they have merit. We don't know that. We don't know the issues around it, but wouldn't be such complaints against a company that's received significant penalties. It's not enough to make me oppose the recommendation, but it does give me some concern, and I wanted to just kind of state that for the record and maybe send the message that the Commission is watching. Thank you, Mr. Chairman.
Seeing no other questions, is there a motion?
Yes, Mr. Chairman, I would move that we note the filing.
Is there a second?
Second.
All in favor?
Aye.
Any opposed? The motion passes. The filing is noted.
The next item, item number 7, is Grady Management, Inc., filed on March 13, 2018, a request for Maryland Utilities to provide whole building aggregate data.
Good morning, Mr. Chairman, Commissioners. Lloyd Spivak for the Commission staff. Grady Management has filed a request that Maryland Utilities be ordered to provide whole building aggregate data to facilitate energy benchmarking. The purpose of this request is to enable owners and managers of commercial and multifamily buildings to achieve certain Energy Star ratings and obtain lower interest rates. As a function of Maryland's electric and gas supply deregulation, suppliers are entitled to receive considerable information detailing customer loads and load profiles with the customer's approval. Grady Management Incorporated specifically requested data from Potomac Edison for a community of apartment buildings in Frederick County, noting that several utilities in Maryland, including Potomac Electric Power and Washington Gas, have made whole building aggregate data available to their commercial and multifamily customers. After discussion between staff and Potomac Edison did provide Grady Management with the data it had requested. In addition, as noted in staff's comments, staff is not aware of any unanswered requests for aggregate whole building data. It is our understanding that the utilities are willing to provide aggregate whole building data and generally have done so. If that changes, we can revisit that issue through the procurement improvement process. With regard to Grady Management's request, staff recommends that the Commission take no further action.
Thank you, Mr. Spivak. Are there any questions?
Yeah, I'm just interested. Is there a formal process that the companies go through? I mean, in this type of case, a company like Grady to request the information, or is it just sort of ad hoc?
I think it's pretty much ad hoc.
It is, okay.
But,
Did
they're entitled to ask for it, and in years past, we've had a lot of requests from suppliers during the procurement improvement process for access to additional types of data, and generally those requests have been granted to the point where at this point we're not really getting many more of those requests because they already do have access to the data.
Okay, and does the request originate, or is it made to the Commission, and the Commission then passes on to the utility, or I'm just interested in this case, what happened? Why did Grady come to the commission?
The request is normally made to the utility. We generally don't have anything to do with it. I think in this case, for some reason, Grady was told they couldn't get the information, or were under the impression that they couldn't get precisely the type of information they were asking for, and that's why they were seeking that relief here.
Okay, and is this sort of an unusual circumstance, or does this happen all the time? In other words, and I mean, is this something we should try to come up with maybe more of a process so it doesn't look like a company out there is getting the runaround, not getting the information that they're requesting that they're entitled to?
No, I mean generally I'd say this is a very unusual request
Okay.
because again the utilities are very good about providing the information that the suppliers ask for, and over the years, to the extent that there were things they wouldn't provide, those issues have mostly been worked out.
Okay.
So it's generally a very routine thing between the suppliers and the utility, and we have no participation in that.
Okay, and at this point, you haven't been able to reach, or the staff has not been able to reach Grady to get a final kind of how this was resolved, or...
Commissioner Richard, John Borkowski for staff. We did have a follow-up last week and early this week with Grady Management, and they have received assurances from Potomac Edison and a contact if they run into issues being able to get this data in the future. And in addition, Grady Management representative indicated they would not be here today, but they agree with or were okay with staff's recommendation of no further action at this time.
Great. Thank you very much.
Commissioner Herman.
Yes, Mr. Spivak, I just have a procedural question. If we take no further action on these requests, are they just kind of hanging out there? And are we trying to sort of close this loop and then a new one would be opened if necessary? I'm just trying to understand this take no action recommendation.
Essentially, there's really nothing for the commission to do. I mean, the request has already been answered. The utility has already provided the information that Grady Management was asking for, and that now we're quite fairly certain includes Potomac Edison. So there's nothing really to be done. And since the utilities already do provide that information, it's kind of hard to say that the request is hanging out there unanswered.
Mm-hmm.
It's already been answered, so there really isn't any action for the commission today.
Okay, thank you.
Commissioner Commissioner O'Donnell.
Can I follow up on that? Might it just be more appropriate for us to have a motion that denies Grady Management's request without prejudice, and that way it'd be closed?
Certainly, Commissioner, if you want to make that motion, that would not be in it.
I wasn't going to question it, but Commissioner Herman questioned. Kind of, it's a little uneasy for us to take an action that takes no action. Because the motion would be the request. If we move that, would be an action.
I think the reason we chose the wording we chose was because, again, there's all the utilities provide the information, and denying the request has some kind of implication in it, or sounds a bit more like there was something improper in the request, and we didn't want to imply that. It was simply more a misunderstanding than anything else.
Wouldn't the without prejudice, though, kind of mitigate that concern of?
It would, and it would certainly make it clear that if people have problems in the future, they can come back in.
I don't feel strongly about it either way. It's just a kind of odd little recommendation.
My issue with denying it without prejudice was that I don't want to send a message that we would be denying a request for information, and therefore that's why I was struggling with what else could there be, and I understand staff probably struggled the same way. So I think I'm comfortable enough with the taking no further action as opposed to denying it, because I'm not sure
I'm comfortable seconding not taking any action.
Yeah, and the reason for my question is just to make sure if there is an issue or problem out there for companies like Grady's to get this information, that we may want to take some action to resolve what problems or runarounds maybe companies are getting. So anyway.
Gotcha. Okay.
Any additional questions? Let me propose to address both Commissioner Herman and O'Donnell's points with this two-part motion, if I may. See if everybody's comfortable with this. We find Grady Management's request to require the Potomac Edison Company to provide whole building aggregate data as moot. And we deny without prejudice Grady Management's request to require all utilities across the state of Maryland to provide aggregate whole building data for the purpose of energy benchmarking.
Okay.
Okay. Is there a second?
Second.
All in favor?
Aye.
Any opposed? The motion passes.
Thank you, Commissioners.
Item number 8 is Baltimore Gas and Electric Company, filed on March 8, 2018, revisions to PSC MDE-6, supplement number 603, Rider 12, prepaid pilot, and supplement number 434 to PSC MDG-9, Rider 17, prepaid pilot, case number 9453, effective August 20th, 2018.
Morning, Mr. Chairman, Commissioners. Annette Garofalo on behalf of Commission staff. On July 19th, Baltimore Gas and Electric filed tariff revisions to its electricity and gas prepaid pilot supplements, which are the subject of case number 9453. These revised tariffs incorporate agreements with members of the prepaid pilot working group, including Commission staff. BGE's most recent prepaid tariff is suspended, and the tariff under consideration is intended to replace the company's suspended tariff. Under the prepaid pilot program, approximately, this is just by way of review, 1,000 customers, if selected to participate, would agree to pay for energy service in advance of use and through communication with the company, keep their accounts open through continued prepayments to BGE. This continued prepayment is intended to avoid service termination. As part of this filing, BGE sought waivers of COMAR sections that would otherwise apply. By order number 88438, issued October 25, 2017, the Commission rejected the pilot tariffs as filed, but approved the pilot, subject to certain modifications, and directed BGE to report back in 90 days on specified items. The COMAR waivers were granted, subject to the modifications dictated in the order, and also subject to final tariff approval. This is BGE's, I believe, fourth tariff. The new terms of the tariff are the result of discussions among members of the working group. Staff recommends that the tariff be adopted with the recognition that upon finalization of BGE's terms and conditions, the tariff may need to be amended. Staff's comments discuss the consensus items in detail. However, 2 items remain in dispute. The first issue is how a pilot customer should be treated in the event the 2 chosen modes of communication meant to enable notice fail. OPC proposes that such a customer should be returned to traditional service immediately and permanently. BGE has offered additional time for the purpose of resolving this matter of failure to communicate, which might be inadvertent, and staff believes this is a proper solution, especially in the case of a pilot program. The second issue deals with the matter in which customers of retail suppliers are billed. WGL Energy has requested that the calculation of a customer's daily balance be done utilizing retail choice rates rather than SOS sales service rates for retail choice customers in the prepaid pilot, and that retail suppliers be provided data to verify the monthly true-up calculation and be informed which of those customers are participating in the pilot. BGE has stated that it will inform suppliers which of their customers are participating in the pilot. However, the cost of daily balance calculations using retail choice rates is high for a pilot, and staff agrees that this may be more appropriate should the pilot be shown to be sufficiently effective to become permanent service. Finally, BGE requests a change in treatment of certain payments. Order number 88438 granted BGE authority to waive a $1.50 payment fee per month for prepaid customers using a a payment transaction, such as a credit card or check, that requires such a fee. BGE now proposes to reimburse the customers rather than waive the fee due to the cost of implementing such a fee waiver. Staff doesn't oppose this tariff change due to the Commission wished to modify its original order. It's important to note that whether the Commission approves BGE's prepaid pilot tariffs as filed or with revisions or does something else, the prepaid pilot working group will continue to meet for the purpose of reviewing BGE's customer-facing materials, including the terms and conditions that customers must sign to join the pilot. Given that the terms and conditions will represent a signed document between BGE and prepaid pilot customers, staff believes that the company should submit the terms and conditions to the Commission for approval prior to customer enrollment in the pilot. It is possible that the tariff will need to be revised at that time based on what is included in the terms and conditions. So, in summary, staff recommends the Commission accept the tariffs for filing as submitted with an effective date of August 20th, including the provision that allows BGE to refund one transaction fee per month. Staff further recommends that the Commission require BGE to obtain approval of the final terms and conditions for the prepaid pilot program at least 45 days before pilot enrollment begins.
Thank you, Ms. Garofalo. Good morning, Ms. Curry.
Good morning, Chairman, Commissioners. Kim Curry, representing Baltimore Gas and Electric Company. I just have 3 points that I'd like to cover this morning. The first staff mentioned was they proposed that BGE file the terms and conditions 45 days before BGE begins enrollment. In the October 25th order, the Commission held that pre-approval of materials, communication materials, was not required, and instead opted for a process which is similar to what's done in Empower, where materials are submitted to the stakeholders for their review. The Commission in the October 25th order noted that this has worked well for Empower and strikes the right balance between stakeholder review and program efficiency. So the way we would see it happening is that we would submit the terms and conditions for stakeholder review. If there was disagreement, then we would bring that disagreement to the Commission for resolution. Otherwise, if there's consensus, we would just simply like to begin distribution of those materials. That way we could take one more item off your plate that you have to rule upon at the weekly administrative meetings. If there's consensus, we wouldn't really need the Commission to specifically approve those terms and conditions. So that's how we proposed handling that. The second item is OPC's proposal that in those instances where BGE cannot confirm receipt of email or text of BGE notifications, that we remove that customer from the prepaid pilot. We disagree with this. We think that the customer should be in control as to whether or not they stay or leave the program, and so BGE unilaterally moving that customer without that customer's input, we do not support. To the extent OPC is concerned that there's a loss of email or texting capability, the BGE has a process, or will put into play a process that will allow a customer to call BGE 24 hours a day and in an automated fashion receive their balance. So what they have, the amount that they have in their account, they'll always have access to. So we don't see there being an instance where a customer does not have access to that information. The third item is the reimbursement versus waiver issue. So BGE proposes to reimburse the $1.50 fee, which means that the customer will get charged it, but get credited it. The order, October 25th order, said waive. Reimbursing accomplishes the same result in that the customer does not get charged the fee. And the reason why we need to do it like this is that we have numerous payment vendors that charge this $1.50 fee, and so having to notify them and engage with them to not charge that fee for the very small set of customers that are enrolled in prepaid could be at a level of complexity that we do not necessarily need. So what we were proposing was to reimburse it. Again, has the same effect as ultimately crediting the customer for that fee, so they ultimately do not end up paying that $1.50 fee. So those are my comments.
Thank you, Ms. Cartier. Thank you for breaking it down along those lines. Are there any other parties to this matter that wish to speak? Mr. Auslander.
Commissioners, Jacob Auslander on behalf of the Maryland Office of People's Counsel. We filed brief comments in response to these tariff revisions, limiting our concern to a previously raised concern that has been discussed this morning, that during the pilot, we believe that BG&E should be required to maintain, required to ensure that there's an open line of communication. Our initial concerns were that the tariff as originally worded would only require a participant to prove that they had an active email account or cell phone service at the outset and would require nothing further. And unfortunately, during the work group process, although there was a lot of many attempts to try to resolve this issue, it was not resolved to OPC satisfaction. And I'd like to highlight that our concern is really a concern about public safety. That we are replacing the robust consumer protection and notice provisions that exist under the law and under various tariff provisions that protect the public from a service termination by providing notice that it's going to occur and allowing, in some cases, the customer time to address an arrearage that might have accrued on the account. And if the messages that are being sent to the customer through email or to their cell phone number are not getting through, then this alternative form of notice during the pilot will not be effective. So in our view, the fact that it's a pilot really should suggest that we should err on the side of caution, and in the situation that a customer is not receiving the messages should lead to the customer being reverted back to post-pay rather than having their service terminated. Now, I think that there was a minor change in the tariff provisions that would say it essentially acknowledges that the customer does have to maintain an active line of communication, but rather than having that lead to the customer being reverted back to post-pay, it just says that BG&E will require them to reestablish the communication within a reasonable time, and that in OPC's view is just too vague to have any meaning. So we reiterate and would ask the Commission to require BG&E to revert customers back to postpay in the event that these messages are not going through.
Thank you, Mr. Auslander.
Good morning, Mr. Chairman, Commissioners. I want to introduce myself. My name is Mel Brennan. I'm the new Executive Director of the Fuel Fund of Maryland, and hope to be in a robust conversation with you all on a variety of issues going forward. Today we're here to talk a little bit about the BGA prepaid pilot and to ultimately urge the Commission to approve that proposal. As you know, Fuel Fund is a nonprofit organization that provides resources to help low-income Maryland families meet their heat and home utility needs. The prepaid pilots focus on supporting client response, customer response to high arrearages is one of our areas of focus. Last year, the average utility arrearage was more than $1,100, and these large bills strain our ability to help, as well as all ratepayers, and they put families at risk of extended service terminations and threaten their health and safety as well as their communities. Fuel Fund staff have seen that when prepaid utility programs are done well, they can offer a new alternative to bill payment for customers who may not thrive under the standard payment policies. And many customers we have seen in other areas around the country with these programs have successfully reduced and even eliminated their arrearages through prepaid utility service. Last year, we presented a series of concerns about the design of the program, and these included the right of customers to return to post-pay at any time, a commitment by BG&E to work with stakeholders on program details, and importantly, to share customer-facing materials, and the need to provide more detail on how energy assistance grants will be allocated for prepaid customers and others. And we're glad to report that through many months of discussion, we've addressed most of these concerns. We urge the Commission to approve the proposal and permit the company to test this approach on a limited voluntary pilot. Most importantly, Fuel Fund is eager to study the results and to determine whether prepaid service, in fact, can offer the value here in Maryland that other utility customers have reported. Thank you.
Thank you, Mr. Brennan. Any other parties? Is WGL Energy in attendance today? Noting their absence, we'll start with a few questions. Ms. Curry, how long would it take for this pilot, if once approved, to get off the ground and become operational?
Here, let me look to my business.
Mr. Chairman, David Kahn with BGE. As I understand your question, are you asking, sir, how long, assuming the Commission should vote approval of the tariff, before we expect to be able to offer it to customers?
That's correct.
We anticipate at this point that we would probably launch the program in first quarter of 2019, probably late in that first quarter, so toward the end of March. And to be specific, we anticipate that would be the point at which we would begin to invite customers to voluntarily enroll in the program. So we expect the first enrollments probably end of March, early April.
Thank you. Staff here recommends a 45-day period before a pilot enrollment begins. If we take that route, do you believe that this would delay the pilot start and move it into the second quarter of 2019?
If the Commission were to require us to bring the final terms and conditions to you for approval at least 45 days prior to our launch, I would say we would make a commitment to do that so as not to delay the launch of the program. So I believe we could do that. At the risk of trying your patience, I would reiterate Ms. Curry's argument simply that if there are any concerns raised by staff about the terms and conditions or any other materials, we feel like that would certainly be appropriate for them to bring to you. Absent that, if there's agreement, we hope that you would sort of look to the stakeholder group, including staff, to make sure those documents are okay.
Thank you. Commissioner Richard.
Yes, thank you. Probably a question for BGE. First with the WGL, I guess, comments, requests that looks like at this point aren't being agreed to. First with the request that retail choice rates be if you're a retail choice customer, that those rates be used in the prepaid. You noted there's a cost, but is that the only reason? Is it just a cost? And is this $348,000 a pretty accurate cost estimate?
Yes, and one of the reason is the major reason is the cost, because we don't have that supplier data today, so we would need to convert to a rate-ready system, and that's the cost that you see referenced there. Could be something we could pursue for full deployment, for this pilot purpose. It's from a cost standpoint, it just doesn't. It wouldn't make sense to include that and eliminate.
And I understand that there's got to be some planning, and one of the objectives I saw in this pilot was to hopefully give meaningful opportunities for the retail suppliers to participate. There's a cost here, but I look at this other list of true-up costs or costs that need to go into the system for the non-usage charges, for the transaction fees or processing fee charges, customer charges. There are a lot of things that are going to have to be handled on a customer by customer basis. So do you have a sense of what all the costs are go into those particular true-ups, and are those in line with what potentially if you could work with the retailers and get some of these retail rates up front? Could those be just one of the list of items that are dealt with in in handling these 1,000 participants in the pilot?
Getting them up front, I don't know if that is a possibility, or how that would actually work in the scheme of things. Like I said, right now our systems are set up where we receive rates from we don't receive the actual rates from the suppliers. We receive a bundled rate. So if that customer's on budget billing, for example, we just receive that. We don't know their individual rates. And to set up a process, we put the estimate in there. It would be, at least like $1.6 million. And again, this doesn't preclude us from looking at those issues when it comes to full deployment, but for purposes of this limited pilot, I mean, we still are very committed to including suppliers.
This is a pilot. It seems like this is when we ought to be looking at some of these issues. I mean, isn't that what a pilot is for? I mean, if we don't know what the difficulties are at the pilot, then how are we just going to figure this out when we go to potentially a full deployment?
Well,
Because again, these charges, I mean, you don't know now what the non-usage charges are going to be, or, you know, who's going to participate with the transaction charges, the processing fee charges, or, you know, any of the, you know, I guess, customer charges. You don't know who's going to be disconnected or not disconnected. So I guess I'm not understanding why, you know, at this point, there's all this uncertainty on the retail, you know, we don't even know how many retail participants there will be, but somehow you've got it all worked out for these other unknown charges.
Well, I believe the charges you're referring to are just charges associated with the pilot itself. If I'm, hopefully I'm not.
Well, I know, I'm trying to deal with the individual participants, you know, maybe unique charges. And so, I mean, how are these unique charges that you know, that you've all accepted you can deal with, any different than potentially a unique charge of a retail customer?
You know, again, I don't know if I think the problem is it's an unknown charge from the suppliers. We don't know what their charges are.
Have you asked them?
Have we asked them?
Well,
for
I mean,
their
we don't know who the participants are yet. And so when the participant arrives and says, "Hey, my retail supplier charges X," I mean, you don't know what their transaction charges or fees are going to be. You don't know what their customer charges may be if they are prorated.
The charges you're referring to, I believe, are BGE related charges or charges associated with the program, and that's different from a third-party charge. That is what we're referring to.
Right, but you would know that charge when the participant, the pilot participant, starts the pilot.
We would know, for example, a customer charge, a BGE customer charge.
Well, maybe I'm not asking this directly, clearly. When somebody signs up for the program and says, "I would like to be a prepaid customer," and I happen to, you know, my retailer is Constellation, and you know, you would know, it's public, what their charges are, the retail charge is for that rate. Why couldn't that just be put into your system at that point?
I don't know that it's public. A lot of these suppliers negotiate different charges for different customers, so it could be different from customer to customer. So I don't know if that charge is publicly posted somewhere.
Have you worked with the retailers at all to try to figure out if this is possible to resolve? That
we did.
At the time of enrollment in the pilot, a customer could say, you know, I'm a Constellation retail customer. You know, please use that rate.
But the problem is it's going to change. So a lot of these suppliers, they have rates that change from month to month. We don't know what their the circumstances of their contracts are. So we would almost have to rely on the customer to tell us every month. So that's why we really would need some sort of automated process, which is what we've proposed. This rate, or one of the options would be the rate using the rate ready process, but there's a cost associated with that. So we would really need to automate that process versus relying on a supplier telling us or a customer telling us. Does that make sense?
I mean, I hear the words, but again, it was one of the objectives of the pilot. It was my understanding was to give retail suppliers a meaningful opportunity to be a part of this. And if their customers are being charged, you know, or at least they're going to get a bill for SOS, and then there's going to be a true up. I don't understand why we have to go through, you know, do this backwards. Why can't we just put the rate in at front so that there can be a meaningful opportunity for retailers to be a participant in this pilot?
So David Kahn again for BGE. I think I understand the questions, Commissioner Richard, and we certainly do want this to be a meaningful opportunity for retail customers as well as SOS customers. So it might help to walk you through very briefly that reconciliation process that you referred to. Our proposal would be, let me start with the basic for an SOS customer. Obviously we know the rate per kilowatt hour per therm for customers who are SOS. And so each day during the course of a month of prepaid experience, we would reduce the customer's account balance by a factor of that SOS rate times the number of kilowatt hours and therms used the prior day, adding in a prorated share of the distribution utility charges, the customer charges, taxes, fees, and surcharges, right? That's the basic. So that at the end of the month, when the actual charges are calculated, as we do for every customer each month, we would expect for those SOS customers that there would be very little difference between the sum of the daily charges and the actual charges at the end of the month. However, for retail supply customers, as Ms. Curry mentioned, for the vast majority of our supply customers, their suppliers have bill-ready service, which means, of course, that we receive the charges at the end of the month, at about the time that we generate the bill. We don't have a way of knowing during the course of the month what those charges were or how they break down into a kilowatt-hour charge. And one example might be, we heard a little bit of this yesterday, if a customer was quoted a certain rate, but the supplier chose to add value by providing a gift card, which could be used to purchase, I'll say, a mini fridge. I'm not sure what that joke means. The rate could change. Obviously, the rate could change at some point during the month. We don't know that until the charges come in. So for all of our electric suppliers and for some of our gas suppliers, they're on bill ready, the only way we could allow the customer in that circumstance to participate in prepaid, and we don't want to exclude any retail customers, is to use a proxy rate until we get the actual rate in. And the proxy rate that we're offering to use is the SOS rate. When that actual charge comes in from the supplier, that's when we do the reconciliation. So we compare the charges we had during the month, and if the customer was effectively paying less for their commodity because the supplier rate was lower, that's going to create a credit. We're going to apply that credit to the customer's prepaid balance immediately. Conversely, if the charges were higher, we're not going to apply a debit immediately. We're going to prorate that debit over the next 30 days so that the customer has a very smooth experience. And the last item I'll add is after 1 month of, say, applying the debit, 1/30th at a time, so long as that rate stays the same, that customer effectively will be paying the supplier's rate because we've sort of adjusted it according to the charges that we just got. Now, when the supplier's rate changes, or if the customer should switch supplier, or switch back to BGE, which could happen in the middle of the month, then their rate will change, but we'll adjust at the end of the month as well. We certainly don't want to exclude any supply customers, and we think this is probably the best way to do it. Now, there are some rate-ready suppliers. WGL is one of them, meaning they provide us the rate at the beginning of the month. We do think we can accommodate that, but as Ms. Curry mentioned, the cost of creating the software and the support and working with our vendors to do that, that cost just for the rate-ready suppliers for this pilot would be upwards of $350,000 to $400,000. For non-ready, for bill-ready suppliers, the first thing that would have to happen is they would need to have the ability to do rate-ready. And we've estimated the transition to accommodate rate-ready from existing bill-ready suppliers, that could be upwards of $1.5 million or more to do that. Should that be something that we should do at some point? We're open to that discussion, absolutely. But for a 1,000-person pilot for 1 year, we felt like those are charges that are probably exorbitant just to test this approach. But we do think the experience is going to be pretty smooth, even for retail supply customers. I'll stop the filibuster.
I appreciate very much. That was a very thorough answer. And again, I have to be honest, I'm somewhat frustrated that there are no retailers here today, or WGL is not here to again, engage a little bit on with their perspective. It is a frustration also that more of this wasn't worked out for the pilot, because again, it was an objective for the retailers to be a part of this, and I'll end that. I'm sure my fellow commissioners are tired of hearing me talk here. So I may have another question, but I would like to hear what the other questions are.
Thank you, Commissioner. Thank you, Mr. Khan. That was helpful in illustrating how the plan works for those that exercise retail choice. Commissioner O'Donnell.
Thank you, Mr. Chairman. I painfully reviewed our April 25th AM and went back just to remind myself of the discussions we had back then. So let me just verify a few of the things from then that were kind of outstanding at that point. Does this most recent tariff submittal include the requested waiver items that we modified regarding consumer protections?
Staff believes it does. The possible outlier is the issue about which OPC is contending, but we think the reasonable time, which although the tariff says reasonable, it's our understanding that it's an additional 5 days, does offer protections. Clearly, the prepaid pilot program will never be able to offer the same protections as traditional service, but we think that we have in the work group discussed those issues, and that though they are handled appropriately in the tariff.
So I just wanted to verify that. I think I read it in the red line of the proposed tariff, but it's there are references to the COMAR sections and.
The termination regulations are referenced. We did debate whether we should state more, but we think that for the customer may or may not look at the tariff. They'll probably look more to the terms and conditions, but for example, our Office of External Relations, with that information and any other official body, including the Commission, we thought that was sufficient.
So is it staff's opinion now that a sufficient amount of the terms and conditions have been memorialized in the tariff, which was quite a bit of our discussion back in April?
Yes, with one exception. So I believe this came up the last time, that there had been a change in something we thought was going to be, had been handled. It was the charge to a customer, $20 if their bill was finaled. We didn't know about that. I don't believe that was brought up in the working group. And it is that sort of thing that is driving our request that the final terms and conditions be brought before you for approval, and we, so that we can look at those and we can say there's nothing new. We would hope that would happen. What's in here is in the tariff. But we think it's more likely, because this is a work in progress, that there'll be one or two things in there that perhaps we would think should be in the tariff, and that is the reason we want the terms and conditions to be brought before you and approved.
Okay. I have a question for staff regarding the waiver of the fee, the one-time waiver or suggested reimbursement of the fee. The switching from a waiver to a reimbursement, and assume we do full-blown implementation of this at the end of the pilot, does the waiver of that fee or the reimbursement of that fee change the cost to the company's ratepayers? In other words, that cost is being socialized across all the ratepayers of the company, and does waiver versus reimbursement, is there a difference in the impact on the socialization of those costs in terms of recovery, rate making, or in any other manner? Is there a difference?
I think our recommendation goes only to the pilot, but I'm going to let...
Okay, well then answer it to the pilot, no problem. I'm just saying it's important information for me to know going forward whether or not we waive or reimburse this.
Dave Hoppeck, on behalf of staff, good morning, commissioners and Mr. Chairman. It's our understanding that there would not be a change in the amount recovered from all ratepayers, whether it was waived or reimbursed.
Okay, fair enough. Thank you. I did have a question for the company, if I might. So I've reviewed the report several times now, the 90-day report, and it wasn't clear to me when the end date is on this, because a lot of it is contingent on implementation schedules. So kind of refresh my memory as to what the intended end date of this prepaid pilot will be.
I believe it's 12 months, but I will let Mr. Khan respond.
Thank you, Commissioner O'Donnell. Using the targeted start date that I mentioned earlier, let's say April 1 for ease, we anticipate that we would be able to enroll the 1,000 customers within 3 months. We hope it'll be quicker than that, but let's just say 3 months at the outside. Our proposal is to allow each of the 1,000 customers to have 12 months of prepaid experience. So that would imply that the last person in, let's say at the end of June, would start the last 12-month period. And 12 months later, June of 2020, that would close the formal part of the pilot. We would be collecting data about all these customers through that point when the last customer experiences the end of their 12 months. Our proposal also includes, and so that cuts it off. Our proposal also includes submitting to you a full evaluation report within 6 months after that. And so that would imply the end of 2020 that we would submit to you that evaluation report. I also want to note that we've proposed, and in the October order, you tentatively approved the idea that customers who end their 12 months of experience in the pilot, who like it and want to remain in prepaid until a ruling from the Commission, be permitted to do that. And again, in your October order, you conditionally or tentatively said you were okay with that. Obviously, if you should rule after the evaluation that the program needs to be shut down, that's when we would inform those customers they need to switch back to postpay.
And we would allow them to remain for some transition period until that occurred.
That's exactly right. We would anticipate certainly there would be some changes between pilot and full deployment, possibly the issues around supply that we've talked about, possibly others that you would request of us.
I'll state the obvious. Certainly, I don't believe it's the intention, certainly not of this commissioner, should I support this, that we drag this pilot on forever so we don't get to 950 enrollees and kind of, oh, we can't quite get over that hurdle to 1,000, and that prolongs this thing forever. So I just want to state for the record that it's not the intention to do that, and that we may have to revisit this should we not reach the 1,000 participant threshold in a timely fashion. I know that's not the intention of the company, and certainly I believe it's not the intention of the Commission should we authorize this pilot.
No, I appreciate that point. In fact, we've made a commitment in our recent filings not to go beyond 6 months. We don't expect it'll take nearly that long. We would hope that if we're a few shy of 1,000, that's sufficient for all to agree that the data will be robust. If it's 950, even if it's 900, we expect that would be a valid sampling. We're going to do our best to get to 1,000, but we will not drag it out forever.
Thank you. I appreciate it. One last question for staff. If we were to accept the recommendation to direct the company to obtain approval for the final terms and conditions for the prepaid pilot program at least 45 days before, as you recommend, if we authorize that, would we have to approve any changes to those terms and conditions since we're approving them in the first instance?
I think I'm going to state something and then they can correct me. So what we envision is terms and conditions will be finalized. They will be filed. We will be familiar with what's in them, but they'll file them with you. If there was something about which we objected, and by objected, since this is being done in a work group, I don't think it'll be so much an objection as something that should be in the tariff that is not there now. Our comments would be done very quickly, and we would bring that to you, and as we are now, we would just ask that be inserted in the tariff, and I think BGE could do that.
Yeah, maybe I'm not being clear though. If we approve the terms and conditions prior to this thing getting off the ground, and then there are subsequent material changes to those terms and conditions, would there be a burden on the company to submit those material changes of what we've already approved to the Commission for review and approval?
The problem we're trying to deal with is a change in the terms and conditions which would affect the tariff language. In other words, if there is something about in the terms and conditions about how the terms and conditions are distributed, or that you're a member of a group of 900 as opposed to 1,000, we don't think that would need to go into the tariff. But there could be issues that should be in the tariff that will be in the terms and conditions hopefully there'll be no changes after this initial approval, but there could be, and Mr.
Okay.
Hoppick might have some ideas as to what we have in mind. Or one of my misters.
David Hoppick again on behalf of staff. So if the commission did decide to approve the final terms and conditions 95 days before enrollment began, we assume that if there were further changes to those terms and conditions, yes, those would need to be brought back to the commission.
Would they be brought to the work group, or would they be filed with the commission in some kind of formal process? How's that work?
I would assume we would attempt to get quick review within the working group and then bring them forward to the commission.
Can I ask the company if the company has the same understanding of that?
I would think that if the terms and conditions are filed with the commission, any subsequent changes would have to be approved by the commission, only because you could end up in a situation when the terms and conditions on our website would be different than what's on file with the commission. So that also is one of the reasons why we think the stakeholder review makes more sense. As you had mentioned in your October 25th order, that it really does, come down to kind of, efficiency of the program and having to have approval for the terms and conditions each time there's a change, is not as streamlined as a process as we would like.
So you're suggesting then in the stakeholder review that any disagreement that may arise in that stakeholder review process could then be brought before us?
Yes, and only in the instance if there's a disagreement. If there's consensus, we would just distribute it to the customers, post it on our website, and go that route.
Okay, thank you. That's all my questions, Mr. Chairman.
And I would be comfortable with the approaches outlined by Baltimore Gas. Does staff have any concern with moving off its position requiring the 45-day tariff filing in advance? Or is staff amenable to BG&E's proposal?
So there'll be a lot of customer-facing materials. There'll be pamphlets. There'll be a number of things which describe the program. We're talking only about the signed terms and conditions. I think we could work with BGE on this and hopefully not have to bring them to you if that's your wish, or bring them to you only if there's a dispute. Our concern is just that we've been in that spot before. We're trying to avoid it, but we could try and avoid it in another way.
Thank you. Commissioner Linton?
Yes, thank you, Mr. Chairman. I actually had a follow-up question to one raised by Commissioner O'Donnell regarding the $20 fee for restarting for customers who have lost their service past the final bill date. I understand that fee is a typical fee that customers who already are in post-pay, that's the kind of fee they would pay. What is that $20 fee designed to capture? What are the costs or expenses that it's designed to capture?
So, Commissioner Linton, again, David Kahn for BGE. Generally, this is the fee that we charge to start service again, whether for previous customers or new customers, and it's intended simply to cover some of those costs, our call center representatives, back office, whatever it may be, to start service for customers. For prepaid, we're proposing the very same treatment as for all other customers. If you're starting service, typically there's that $20 fee. I would note that after discussions with staff and other stakeholders, we did agree to propose that prepaid customers be given a longer time period after, should they get disconnected, before their account goes to final and they would be asked to start service again. So typically today, a customer has 10 days after disconnection, if they take no action before we end their account, and if they should start up again, the start service fee applies. But for prepaid, that's 10 business days. For prepaid, we're proposing 20 business days. And so our hope is that, again, with a very low hurdle to get reconnected under prepaid, because people won't owe much, very few, if any, of those customers will reach that point if they don't want to.
So this is a fee that they would have to pay in advance of getting reconnected under prepay, or is this a fee that's applied over the course of the month?
So this is a fee that we charge as a condition of starting service. I believe it's permitted in COMAR, it's in our tariffs, and again, it's a fee that applies to all customers who are applying for service.
Okay. So my second set of questions might be for the Office of People's Counsel.
I can take those, Mr.
You can take those, certainly. And I wanted to make sure that the OPC, of course, raised concern about customers that were unable to receive the different notices that the companies may send out. The company did propose a solution, and I wanted to make sure that OPC was what your position on that solution was.
Well, I'm not sure that I'm aware of the solution for, as far as the notice. I mean, we had discussed some solutions that would have been acceptable, potentially acceptable anyway, to OPC in the work group setting. Unfortunately, we were not able to reach consensus on those. And I think at this point, because that concern is so important to our office, and we're not satisfied with the status quo as reflected in the current tariff language before the Commission, that we would request that the Commission direct BG&E to actually ensure that customers are receiving these messages. So, for example, one possible solution could be if there is no indication that the messages are getting through, rather than shutting off service, to mail a postcard to the service address. It would be not quite as effective as the type of mailed notices that a customer on traditional postpay would receive, but it would provide an additional level of protection and guard against the situation where a customer might have had access to a cell phone line at the outset of joining the program, but at some point afterwards lost they might have had a prepaid cell phone line that expired, and so they're not receiving messages on that line anymore.
Was that a proposal that was made during the work group?
That was one of the suggestions. It was not. It was discussed very informally, but that was one of the attempts to reach consensus on this issue. And what I'm concerned about with the tariff language as it reads now is it's just too vague to really be enforceable. It just says reasonable steps. I mean, I'm not sure exactly what that means. And if it wasn't as important of a concern to OPC, it might be something that for example, we wanted there to be more descriptions of what provisions are what COMAR provisions are being waived by the customer in the tariff. Staff mentioned some of those earlier. We're satisfied at this point that at least the reference to the COMAR provisions themselves, represent an improvement over what the tariff originally looked like. However, on this issue, we're not satisfied that customers will receive the level, anywhere near the level of protection against a situation where the power might be cut off and them being unaware of exactly when that. They might have an idea in their head that, oh, I'm paid up and I'm good until for the next 14 days, and the power gets cut off that weekend. So we're concerned that in the situation where the customer, where BG&E can't ensure that the customer has received the message, that they're proceeding with a termination anyway, even though, according to the tariff, the obligation for the customer to maintain that line of communication is very clear. So it strikes us as a little inconsistent to have that be a explicit criteria that the customer must comply with according to the tariff, but that there be no enforcement of that obligation.
Okay. Thank you. And so I have to rotate back to BGE then. So
before you go to
sorry.
another If I may, Mr. Cross reminds me that for customers who are on prepay, who are low income, there are special arrangements, and if you'd like to hear him discuss that, he's available.
Okay. Well, I wouldn't mind hearing that, but I'd like to hear from BGE to see if there's an objection to sending something in writing to a customer like this. I mean, during the course of the pilot, of course, written notices are something that are fairly common throughout Comar. So is there a reason for not supporting that?
The issue would be timing. So if it takes mail 3 days to arrive to you, it really wouldn't be a useful tool. That's why getting that instantaneous call BGE, get an automated message of your balance is a better option and something we were going to do anyway. So the timing really would be the issue. It really wouldn't be effective to send something via mail. Given the turnaround time by the time they get that communication.
Isn't it just a form of backstop or protective last step kind of gesture?
If I could add, we've seen from other utilities around the country, the customers who've chosen prepay, this tends to be a program for customers who prefer electronic communications, whether email or text. Unfortunately, we've heard that not all of our customers read all the things that we send them in the mail as much as we want them to. This is a group of customers in prepay that really have said to us, we want you to communicate by the method that we prefer. I'd also add that one of the other enhancements that we've offered and have incorporated into our proposal is before we said that if a customer was getting close to disconnect because of a low balance, they could call us and ask for an extension up to 5 days, during which they would go into arrears, but we would protect their service for that time as long as they paid what was owed before they get to a new that 5 days. What we did offer in light of the concerns raised was even if a customer has been disconnected, they can call us and be reconnected immediately without need for any payment and get that 5-day extension. So our feeling is the nature of the customer who seems to prefer prepaid is they want these communications in the method they want. We're going to make it incredibly easy for them to be reconnected should they get disconnected, and to be reconnected immediately, and any customer who doesn't find the program is working for them would be able to switch back to postpay at any point. Even if they've been disconnected, even if they owe us money, we would immediately effect that switch back to postpay, and they would wait for the next bill and go back into the regular collections processes. I think at the end of the day, with proper and clear customer education materials and communications, we do want to trust these customers to choose a program that they think works for them and give them some ownership and authority over their service.
And I certainly think that's what that's one of the benefits that we've seen, at least we've heard, could be a benefit through prepay. We've also heard, though, that it tends to have, on a national level at least, a number of customers that are either low income or hoping to have their service restored because of an outstanding arrear that they can resolve through some type of extended program. And so they may not have access to the same types of electronic communication, at least as a reliable nature as and I won't take shots at millennials, but folks who are younger than you or I, who may be more, and that includes my colleague who's very technologically involved. But there are certainly some folks who may run into some issue with receiving that communication.
Mm-hmm.
There may be others that have other challenges, such as they're out of town,
mm-hmm.
and for whatever reason are not aware of the fact that that's the reason for the service denial until they return home and find that the power's off. And sometimes something as simple as a 15-cent postcard would jar their memory and let them know that, oh, this is what I'm supposed to do now, as opposed to searching for some other issue. I just think for purposes of a pilot, we're talking about potentially a very small number of notices of this nature during the course of it, and it doesn't appear to be an issue that should cause a lot of challenge in terms of implementation.
Yeah, so I think to affect that, behind the scenes, we would have to examine ways to be able to, in a timely manner, capture and catalog and respond to these instances of a failure for a message to be delivered or even read or received. Some of the methods are easier than others. We're not even aware, frankly, of a text message method of determining did the customer see that or did it get through. That's why I think to some degree we do want to put some responsibility on the customer to say this is how the program works. As Ms. Curry mentioned, they can always call in and get that account balance and the estimate of days remaining. If they have any access to a computer anywhere, at the library or a friend's house, wherever it may be, they can go online anytime, day or night, to get that information. And I would add, it's part of the reason we're also offering the auto replenishment feature, whereby customers who choose to could sign up and have an automated payment made anytime their balance gets down to within 2 days of a zero balance, so that they are never at risk of disconnect if they choose to sign up for that service. A little bit like the Easy Pass, the toll booth method. So we feel that there are a lot of those protections in there. I can't tell you right now what the level of complexity or cost might be to set up that system to ensure that we can always catch and send out in a timely manner the postcard, make sure that the customer receives it, reads it, and responds to it for a 1,000-person pilot, much less a full deployment. So I don't want to make promises that might raise the cost. We've already been asked appropriately by other stakeholders, including staff, about the potential costs of the pilot. We do want to keep it as manageable as we can.
Okay. And I won't continue on this path, but just very briefly, if you could just refresh my recollection as to what communications the company sends to the customer after the service has been denied, been turned off for lack of payment.
Under prepaid or under
prepaid?
Our intention would be to continue sending a daily notice to the customer with the amount of arrears at that point, because likely they would be slightly in arrears, or maybe more if they had the 5-day extension. So every day they would continue to get a notice saying this is how much would be needed to pay to restore service.
And that would
every single day in disconnection until their account is closed.
And that would be sent through the same means of communication that were used while the service was on.
Yeah, and of course we would anticipate that any customer who has experienced a disconnection would contact us right away. Possibly, with the exception of the example you cited, someone has gone out of town. We would definitely recommend, the auto replenishment service for anyone who knows they may be traveling for work or otherwise regularly.
Okay. All right. Thank you. I had one other question regarding the inclusion of Schedule EV. My understanding is that that was something that the parties agreed to. I just wanted to know what the rationale for that was, if there was...
I'm sorry, is it scheduled EV?
EV.
Benjamin Baker on behalf of staff, commissioners, and chairman. Are you talking about the time of use rate, RL? Sorry?
I was talking about EV, but also the time of use rate was also included.
So I think what any residential I think our intent is any residential tariff can be part of this pilot, and that's a part of our discussion with them. With this was originally there was an exclusion for time of use customers, and in our discussion with them, we were like, why are you doing that if we're allowing retail choice to be on here? And so basically the agreement was to put the time of use customers in the same bucket as the retail choice in that monthly true up. So there was no sort of special exclusion for customers, residential customers who are on BGE's tariff, not for the retail choice customers.
Okay. Just so that all of us are on the same page, and thank you to my colleague, I'm looking at August 8th, your August 8th buck sheet, page 2 at the bottom, where you have the summary of filing. And there's a specific reference there to inclusion of rate schedules EV and R. So I am...
That should say RL. Sorry, that's a typo.
Okay. So it was the purpose then for including Schedule EV was just to include other tariffs that are related to residential service?
Right. Yeah. So essentially, because some of the retail in the work group discussions, the retail community wasn't exactly thrilled about having some of their customers in this pilot. And so when BG submitted their original tariff, there was language along the lines of the time of use customers would not be included in the pilot. And so that seemed to me a little bit like a double standard. So in discussions with them, we were discussing, well, why can't they also be part of the true-up method that the retail choice customers are going to be a part of? So the time of use customers won't be, they're going to be under the same method as the retail choice customers will be, which is they will be receiving the SOS rate until their bill is trued up at the end of the month, which has been described by Dave Kahn.
Okay. I would think that electric vehicle customers, their charging patterns, et cetera, and the different reasons they have, incentives, reasons they have for charging at different times of day, things of that sort, might produce some different patterns for using prepaid. So it's an interesting reason to include it. But I was just curious as to what, if there was discussion about that at the work group, if there was some other issue that the work group thought would be worth including EV in there, was worth exploring. There's some information we hope we would find out, but
no, yes, we have not discussed including the electric vehicle. There was no discussion including the electric vehicle tariff in the pilot, but maybe BG has more information on that.
Yes, BG is fine with that. The EV rate is sort of another variation on a time of use, and we would expect to apply that rate structure as Mr. Baker's described it.
all right, that's all I had. Thank you, Mr. Chairman.
Thank you. Commissioner Herman.
So, first of all, Ms. Curry, is 5 days, are these all business days?
The 5 days you're referring to are...
In the tariff?
Let me just confirm.
5-day extension? Item number 12. Customers eligible, 5 days extension, so on and so forth. First paragraph on page 88 of the red line.
So,
am I looking at the wrong version or something?
5 business days, because we would never disconnect.
I can't hear you, sorry.
Yeah, I see where you're referring to. It does say 5-day, and that typically means calendar days, but it would be 5 business days.
5 business days, okay. So this kind of goes to my technical question. The technical question I have relates to the terms and conditions and the request not to have to get those approved. You currently have terms and conditions in your tariff that are part of your tariff, is that right?
Are you referring to prepaid or another?
No, I'm referring to your current tariff that's approved.
Terms and conditions, yes.
Yes, right.
Well, we have terms, not something that's formally listed as terms and
conditions. Well, yeah,
conditions.
it does say terms and conditions in the tariff. Because I'm just looking at it right here on my computer. So I'm trying to understand what's different between these terms and conditions that are approved in your tariff and whether you're just calling an individual contract that's more of a communication, a term and condition. I'm trying to understand if there's a distinction between the two.
Okay, when you said you're pointing to our tariff, are you talking about prepaid? I just want to make sure I'm on the same
No,
page with you.
your currently approved tariff has terms and conditions in it, about all the tariffs do, about, how you get service and things like that. They're
yes,
called
that's
terms
what you
and
mean. Yes, we do
right.
have that.
So I'm trying to understand what, by using the words terms and conditions, I automatically think terms and conditions in a tariff that's approved, and I'm trying to understand what the difference is, if any. Is this more of a customer communication, as you said? This is a more of a communication with the customer than it is what I would call a technical term and condition. So that's really where I'm trying to understand where my confusion lies.
Yeah, the answer is yes. The big difference will be, although the customer does not execute it, or maybe they do, it's more or less, these are terms we want to make sure that the customer are aware of. Having them buried in the tariff, not a lot of customers are going to read the tariff. So really the purpose of the terms and conditions is to have a separate document that the customer has, they could see, and that they could focus on versus burying it in the tariff. So that would really be the difference. But in terms of what's in there, the language, the terms and conditions, the actual specific text, it's going to be the same.
I'm not sure I understand. I
mean,
don't understand that. I'm sorry.
Okay. You were
What
asking,
language is going to be the same?
I'm assuming things like in the terms and conditions, like a customer, if they have a medical certificate, then they're unable to be on the program. They have to maintain an email communication. Those are items that are in the tariff that would be in the terms and conditions.
Okay. So
that's what I was
it's really
referring to.
more
Sorry
of
for the
a sort of a description of the service and the rules of being in the prepaid pilot for customers. So it's not, just trying to make sure that we're not starting down a road where we're not approving terms and conditions of service, and that's really where I'm headed. And I wanted to figure out how we avoid that situation, because I don't want to start we have a pilot here and then there's terms and conditions and then they're approved. So I'm really it really is a technicality, but to me it could be an important one.
And just so I'm clear on what you're asking if there are additional items in the terms and conditions that will go on the website versus what's in the tariff. Is that a proper way to characterize what you're asking?
No, what I'm really saying is that right now, for the terms and conditions of service from BGE, they are approved by the commission, and they're included in your tariff and everything else. And so I'm trying to understand what is in what you're calling the terms and conditions for the prepaid pilot that differs. How is it different from the terms and conditions that exist in the current tariff? And is there a distinction that I can sort of feel comfortable with, so that I'm saying, it's okay not to approve terms and conditions of service?
Thank you for that clarification. There are some distinctions. There are some things that are included in the terms and conditions that go to the customer that aren't in the tariff. And I'll let Mr. Khan give a few examples.
And Ms. Curry, just to be clear, earlier you stated that if we do not go with a 45-day pre-approval here, and you need no final approval, the group would submit terms and conditions for our review if consensus is reached. So that your use of the word terms and conditions there is not equivalent to what's in the tariff. Is that correct?
That is correct.
Okay, I think that cleared up some confusion for me. All right, thank you. Mr. Khan.
So one example of an item that we would expect to put in the terms and conditions that probably wouldn't go in the tariff would be some alerts to customers about health and safety concerns if service should be disconnected. We want to make sure that those terms and conditions, really it's an education document. We're going to ask customers to read it and to verify, to certify that they've read it. So we do expect to add a number of different items by way of education and in some cases warning to customers in the terms and conditions that aren't appropriate for a tariff, that wouldn't be in the tariff. I will say, as Ms. Curry has noted, all the important kind of rules and procedures and commitments that we would make that are in the tariff, we certainly will put in the terms and conditions, but the terms and conditions will include more. It's more of a customer education document.
Okay, thank you.
Your Honors, if I may, I just want to stress that one of the reasons staff is so concerned about the terms and conditions is that you could even make the argument that they actually are more binding than the tariff, because they're really a contract between BGE and the customer on the prepaid pilot. So the customer has no experience with the pilot. This is a wholly new service. They're signing that they agree to participate in this pilot. We want to be sure that there's nothing in those terms and conditions that the Commission's not familiar with and that are not appropriate to be and necessary to be included in the tariff.
Right. So, Ms. Garofalo, I understand that, and let's, hypothetically speaking, if something needed to be changed in the terms and conditions, and there, we would have to get approval for that. Is based on, if we approved it, we'd have to approve a change.
Correct.
Right.
That is correct.
Okay.
That is the downside of that.
Right. And Ms. Curry and Mr. Khan, and if this same kind of approval wouldn't apply to your general sort of discussions about, your general education materials and things like that. That's not been proposed that there be approval or anything like that, is there? Has there been?
Our understanding of what staff has proposed would not include formally bringing to you any of the other customer-facing materials. We do view the terms and conditions as one of a number of customer-facing materials. And I think I need to amend my answer to the Chairman's question earlier about this approval. Would it affect the timeline and the time to launch? And the answer, as I think about it, is it could. If we're required to bring to you terms and conditions for your approval after staff and other stakeholders have already reviewed them, certainly, depending on how long you chose to take to respond to that, that could push back our launch timeline. So I want to make sure I was comprehensive in that answer.
I'm done. Thank you.
Follow up?
Please.
There's been a lot of discussion regarding notice, and obviously you've heard the commissioners one way or another express concerns about that. We're obviously sensitive to consumer protections. The legislature is very concerned about that. It's public safety, and we all have to be very cognizant of that. We know the company is as well. Right now, you plan to roll out late first quarter of 2019, which gives me some comfort. You're getting into the warmer weather season. You're out of the harsh cold of winter. Should the company get into some kind of delay that's unforeseen at this point that would move you into a cold month implementation, either moving it forward or moving it back, one way or the other, would the company commit to informing the commission of that change? Because it would give me some concern if we roll this pilot out in the dead of winter, or when approaching the dead of winter, for obvious reasons.
Yes, we would commit to that.
All right, fair enough. That gives me some comfort with regard to the notice provisions. If you roll it out in the warmer months, and you have kinks in the notifications, or you have unforeseen disconnections, at least you're less likely to be jeopardizing somebody. So that would give me some comfort that you would at least come back to us before you tried to roll that out in a cold month. I appreciate that. I have a question regarding the public review of pilot results by the commission. In your report, you committed to, well, I'll just read it. BG&E will file the report detailing the pilot results with the commission, which is good. But Appendix 2 to your report is the detailing of the evaluation that will occur by Apprise Incorporated of Princeton, New Jersey. And at the end of that, it says Apprise will file with BG&E a report of the evaluation and analysis of the pilot. Will the company submit Apprise's report to the commission in toto as it's submitted to BG&E?
Absolutely.
Okay, I think that's important to know. I don't want a kind of a watered down, kind of abridged version of that.
Absolutely.
I'd like to see
Part of the reason that we selected Apprise from among bidders was their reputation for integrity. They have no interest in subjecting their report to editing by us, and we have no intention to do that.
Okay, very good. Thank you. I appreciate that. I think that we can all learn a lot from that raw report. Thank you.
Commissioner Richard.
Just one other follow-up. I think this is for staff and possibly OPC as well. Is there going to be a review of the materials that the customer, the potential enrollees in the pilot, will receive? And I ask that because there's a lot of complexity to this. I mean, people need to know that after 20 days they will be disconnected or have to reapply. There's a lot of there's only one transaction fee credit. Just a number of things that. The customer charge, for instance, will be just because they're not, if they've exceeded the prepay, they're still going to be charged. Those types of things. So, is that something that OPC and staff will be reviewing to make sure that we are adequately notifying potential customers of these complexities?
Yes, Mr. Hoppeck can give you some detail on that.
David Hoppeck again on behalf of staff. So yes, there is the terms and conditions which we are requesting.
Okay, so that'll be part of that.
That will be part of that. There will be work group review of that. as we've spoken at length about, we've requested that go through final approval through you. There's going to be a frequently asked questions, which is 3 or 4 page document, kind of typical things people might think about to raise for customers. That has already been presented, not in final form, but that will be reviewed by the working group. There is as of now, about 2-page fact sheet for retail supply customers, explicitly explaining how the true-up process is going to work and the fact that you will be charged the SOS rate for your daily balance calculation. But then when we get to the end of the billing cycle, that's when you will actually, you will pay your retail rate as well. BG has sent us some of the materials that will be on the website as well as things like email promotions and things like that. So all of that material, all of the customer-facing material, explaining and promoting the prepaid pilot will be reviewed by the working group.
By the work group. Great. Thank you very much.
Thank you. Any additional questions? So we've discussed a number of issues today regarding supplier rates, whether or not we need the 40-day advisement period, OPC's concern with regard to notification and whether or not the customer should receive some other type of confirmation that BG&E is about to take some type of action if there's not sufficient funds in their account. I believe at this time I would like to propose that the Commission take this under a brief advisement period so that we could resolve these issues, issue a written paper, hopefully in a very short period of time without the need to come back to a further administrative meeting. That would necessitate that we suspend the tariff for a minimum, hopefully a brief period of time in which for us to reach our determination. Do commissioners have any concerns with that approach? Okay. That being said, I guess we would take a vote to put this under advisement, suspend the tariff for a 30-day or less period, whichever comes first, subject to written determination by this Commission. All in favor?
Aye.
Any opposed? Thank you. Madam Secretary, the next item, please.
Item number 9 is Synergen Solar LLC, filed on June 18, 2018. Request for regulatory relief from Community Solar Pilot Program operational deadlines for projects in Prince George's County.
Annette Garofalo again on behalf of Commission staff. Synergen Solar has Commission authorization to act as a community solar energy generating station in a portion of the Potomac Electric Power Company's service territory located in Prince George's County and has cleared PEPCO's interconnection queue. Synergen states that it has met unforeseen permitting delays that were not overcome until I believe it's July 25th. I think our comments say July 26th, 2018, and it seeks an extension of 8 months or until late March 2018. Synergen does not allege a legal challenge. Under Comar 20-620304C1, a project that fails to begin operating within 12 months of submission of a completed application by the subscriber organization shall be removed by the electric company from its pilot program queue unless the subscriber organization of the project provides to the electric company an additional deposit of $50 per kilowatt to maintain its position within the pilot program queue. A project that fails to begin operating within 18 months of application must be removed from the electric company's pilot program queue, absent a pending legal challenge. So Synergen is not facing a pending legal challenge. Under Comar 20-620304C3B, it has 6 months remaining in which to complete its development. Under Comar 2062, which was designed to govern a 3-year pilot program, a given project is allowed only 1/2 of the total pilot period in which to make a given project operational. Public Utilities Section 7306.2D15 requires that the Commission limit the program in such a way that the Commission may conduct a meaningful study of its results. The 18-month limitation on construction, which was put into regulations, is an important piece of that limitation. There's also the matter of equity. There were a number of entities that applied for approval as a CGIS. They did not get that because the project queues filled up. And staff recommends that Synergen be directed to operate within the confines of 2062. And we recommend that their waiver, request for a waiver be denied. And in addition, we recommend that their request for a waiver be denied. So I think it was last week or the week before, you did grant a waiver to an entity in Anne Arundel County, which was foreclosed from going forward. That's not the case with Synergen, and that is the reason that we put this before you in this way. Synergen will be a little bit shy of what it's saying it needs, but we think as a matter of equity, and that's appropriate, and we also think that it's going to be very hard going forward for the commission staff rather, to decide, well, I don't know. 2 months, that's not so long. 2 weeks, that's really okay. What about 4 months, or in this case, the original thing asked for 8 months? We don't know how to make those decisions, and so we ask you simply to enforce the regulations and to deny this application.
Thank you, Ms. Garofalo.
Good morning, Mr. Chairman, Commissioners. Todd Chasen on behalf of the applicant this morning. Let me first frame up what we're talking about here. When we originally filed our request, we were asking for about an 8-month extension. Since that filing about a month ago, we have paid for the 6-month extension. That's about a $250,000 investment, which takes us until February. We're now asking for a little under 2 months. It's about 6 weeks until late March. So at the moment, as of right, they have until early February to construct and operate the project. The request today is limited to that extra 6 weeks or so that takes us to late March. The primary reasoning for that really is weather related. Even if we manage to get everything lined up, if we're preparing to begin construction in February, Maryland weather being what it is, if we run into bad weather, and as we've seen in the last couple of months, that seems to be getting worse, not better. We're concerned that we wouldn't be able to make it operational. We're in the process now of seeking financing, additional financing for the project, and so as the project is being reviewed and being decided on for financing and investment, part of what they're looking at is this money going to be at risk if we can't do it by February the 15th or February the 3rd, the end of February, and we think that this additional 6 weeks would allow for that to happen. So that's the requested time. In response to what staff is suggesting, I think there's no dispute but that this applicant has been diligently pursuing its project. It has invested over $600,000. It has paid over $250,000 for the extra 6 months. They're all in. Unlike some of the other requests that you have, including the one from me that she was referring to back in June, we now know what the delay was. It's done. There is no moratorium here. There is no appeal that's pending. We now have our permits and we're able to continue to move forward. You will not see us back here on this project for any additional time. The equities that were referenced by staff strongly point in the favor of keeping this project moving. Absolutely, if this were a case where you were able to point to some dilatory action by the applicant, then that would be perfect reason for you to deny this. There's no question about that. In looking at how much time, and I understand what staff is saying about 2 weeks, 2 months, or whatever, I think the only rational reason for a decision here is to tie it to the amount of the delay that's not the applicant's fault. Again, applicant's fault, forget it. You don't get any extra time. But for those who have been diligently moving forward, who are clearly not squatting in position, but are rather actually trying to move forward their project, where a local jurisdiction and its process, whether it's by moratorium, whether it's by appeal, whether it's by staffing issues, whether it's by the amount of the mandatory referral timing review that we have in this case, then that's the amount of time that's appropriate. Arguably, this applicant could seek the full 8 months. The delay is entirely based on what's happened at the local level. We've taken responsibility for 6 months, even though I don't believe that this applicant is at fault for that, and is simply asking that the state chip in an extra 6 weeks or so. And so that's our request and why we think that this one should be granted.
Thank you, Mr. Chasen. Can you elaborate a little on the permitting delays that you experienced at the county level?
Sure. If you look at the second page at the top of our first letter that we had submitted, you'll see that we've outlined 3 basic reasons. There's a 60-day statutory review period for mandatory referrals in Prince George's County. When we applied, assuming that that was going to be a 60-day delay, we were told, we'll be happy to review this for you as long as you waive the 60 days. And the result was 120 days. There was an additional road frontage permit that was added later in the project that added some additional time for application and review. And then the third reason was simply a staffing. As these projects have moved forward, both in community solar and in other solar programs, there has been a bit of an overwhelming of staff within some of these local jurisdictions, including Prince George's County. They were very upfront and frank with us, and there's been no dispute about this, that their staffing caused additional delays. And so that's the entire 7 or 8 months that's there. It cumulatively adds up to that.
Thank you. Do the commissioners have questions? Commissioner O'Donnell.
Did I understand you to say, Mr. Chasen, that you have all approvals necessary now to proceed?
That's correct.
Okay. If the commission were to find, for staff, if the commission were to find that good cause has been shown here and grant the extension, we wouldn't be bound in a precedential nature to future applications for extension, right?
Well, I like to think that's the case, although every order contributes to your body of decision.
But the circumstances are going to change and the causes are going to change.
Right. And staff doesn't disagree that this is a small, in the greater scheme of things, at this point, now that 8 months has shrunk to 6 weeks,
approximately,
it's not as major a change. However, should you do that, we would appreciate some guidance. And I notice that I have someone behind me who maybe. All right. And so I think that Mr. Vanderhagen is going to add to my answer.
Thank you, Ms. Grappolo. Good morning, Mr. Chairman, Commissioners. Bill Vanderhagen on behalf of staff. To follow up, the concern we have regarding granting this, it may be that it would create an incentive for others to seek and bring before the Commission, similar requests for delays. The concern I would like to raise here is that the capacity for the categories, I believe, are in contention. There are others who did not receive capacity for some of the projects that were not granted capacity because they didn't get in. Potentially, should the Commission award an extension for something that is not clearly laid out within the regulations, there may be those who would pursue a complaint saying that they would have received that capacity themselves, or that capacity would have been made available in year 2 or 3 of the program. So it does create a potential risk that others will feel that the rules were being unfairly applied, and that they would have been disadvantaged by granting the extension because they would have been ready to take that capacity in an additional project. So that is just an additional concern.
So are you suggesting that we deny this 6-week extension, and if the project doesn't meet the statutory 18 months, that we give that capacity to another worthy applicant?
That is the way, from my understanding, the rules would work, is that if this project was not completed in time, it would be removed.
I know, but that's not what I'm asking you. I'm asking you, are you suggesting we should do that we should leave them invest this money, get right up to the 18-month period, and then yank the capacity and give it to somebody else, even though they may have shown good cause for this?
I think we're suggesting that, yes, that they have not indicated that they will not be able to complete. I think there's a question as to whether or not they will be able to complete it at this point, but we don't have nothing is stopping them from moving forward. I think it's just a matter of being fair to all of the applicants who didn't get capacity. All of the 18-month timeline was put together by the working group and recommended in the regulations by many of the stakeholders, including some of the developers that are in the program. So I hear from other developers that that we've made the sauce and we should use it. So.
Part of the sauce is that we have to evaluate good causes shown when they're shown to us. So we have that capacity. Mr. Chasen, let me ask you this. In your initial filing, you hung your hat on the notion that investors may not continue to invest in this project if we didn't grant the 8-month waiver. Now you're down to the 6-week weather concern in February, construction concern. Does that mitigate the investors' uncertainty going forward? And could we, in other words, could we hold this in abeyance until we get closer to that period? And if you need a little extra time, we could probably reevaluate it at that point. That way we don't get the camel's nose under the tent on these things, because that's a valid concern I believe staff has.
So I think that the chilling effect here on both this and other projects would be substantial. I think that the problem that you run into is that those people who are evaluating this, and there's an army of them, look at this and say, they didn't grant it.
See, now you're alluding to the precedential nature of such a decision for other things outside of this particular case, and I want to stay focused on this particular case because I don't want to set precedent or signal precedents for other cases. I absolutely do not want to do that.
And I agree with you. The issue in this one will be how this is viewed by the people involved in this project. As much money has already been spent, upwards of $1 million, that much more needs to be invested, much more, in order to actually get into construction. And the risk that we're going to get to that date and not be able to flip the switch is going to be greater. I think it would be a bad investment at that point, even though it's just a few weeks. We're not here asking for this lightly. If we thought that this was a trivial additional amount of time, we would not be here.
So I'm sympathetic, obviously, to that, but we're trying to balance a couple interests here. At least I am in my mind, to balance the interest of not opening up the floodgates on these requests and making sure that this project could go forward. And I'm sympathetic to it. It's brownfields. It's a good project. It's I don't. We've approved CSEGs. We want CSEGs to be successful, so there's not a concern there. And we're not going to also blindly adhere, I don't think we would, to some 18-month rule that doesn't take into consideration good cause. So I don't know if I'm being clear on that. I don't know if that helps you or not. But.
No, I think that's very clear. And I think that what we're seeing is that I think you're absolutely correct that, and the reason you're not hearing me talk about the other projects before or after this one is because I think you're right. It is the facts and circumstances of each individual one that need to drive this.
Do we have any more of these requests pending? This is 2 months old.
We have at least 5. We might have 7.
Commissioner Harmon.
Mr. Chasen, you've said that you're pursuing additional financing now. That's correct?
Correct.
Do you have a timeline for when you think that financing might be obtained?
Sure. What we've said in the, I believe the second letter that we had filed is that we would spend the next month or two in that process, and then once that's completed, we would be moving forward with construction.
Right. So, what happens if you didn't get it within that month or two? Would you not be able to complete? Would you be back again for another one, for another request?
I doubt it. I can't tell you for certain, but as I said before in response to Commissioner O'Donnell, I don't think that this one is going to be back again. If we haven't managed to secure the financing in the next 2 months, there's some other problem. But now that we have the property entitled, now that we have the permits, now that we're ready to go, and obviously we're pretty refined on this, knowing a number as precise as 6 weeks, how this thing stacks up, I think we're going to get the financing in the next 6 months, or the project will go away. I don't think that it's going to be an issue of coming back. I think that they're going to get the financing. It takes some time to go through that process.
Would you be willing to provide a status report to the commission with respect to the progress, so that, we would be able to, I mean, I guess what I'm trying to avoid is let's say something were to happen and you didn't get financing, are we going to have to wait all the way until March 25th and it's not operational before we have that notice that it wasn't constructed?
No, Your Honor. We would be more than happy to provide you confirmation that we've gotten the financing or that we're abandoning the project.
And that you're on status, you're on
Absolutely.
target for March 25th.
Yes, that's quite reasonable.
Okay, thank you.
I just would inquire staff, how is this not exactly like Anne Arundel County situation? I mean, we have a situation, we're not talking about a legal challenge here. We're talking about, in that case, the county decided to create this moratorium. So they took an action. You can almost say in Prince George's County, they just didn't take action fast enough. So it seems like we've already, if we want to call these precedent, we've already kind of accepted during this pilot phase at least that there are circumstances that maybe were unanticipated. We're in a pilot that may warrant making exceptions, and so again, I'm confused. When as reading the buck sheet, I read it up and was rather surprised by the last page. It suddenly we deny. It didn't make sense to me.
Well, we wanted you to have a full
Okay.
feeling for the facts, but without some of the confusion that it was in the first letter because circumstances change. What I would say is that Anne Arundel was a harder one for you, in that the moratorium, while not a legal challenge, was in the nature of a legal challenge. The projects could not go forward. Here, there are regulatory hurdles to go over, and I should mention that when we were drafting these regulations, that staff didn't think of this 18 months or the 12-month moratorium. This was brought up by the people who were interested in developing these generating stations, and many of whom were experienced, and they were concerned about the queues being clogged with, clogged for want of a better word, with people who maybe wouldn't finish, and they didn't want that to happen. So I don't know, I can't speak for Mr. Vanderheyden, but certainly I have no experience developing a community solar facility. But we took those concerns to heart, and we've put them in the regulations. I would say that should you want to grant this on the facts today, you could distinguish your order by looking to the fact that these are a type that is built on, I believe, built on landfill, on a brownfield, and so those are that's an important type to have in the study,
Right.
and so you might want to consider that should you grant it. Although we also support some reporting, because these things can change very quickly, and I don't think the fact that that there's zoning requirements and hang-ups is a surprise to anyone who's in this field.
Okay. Well, I appreciate that answer, but again, I think we're being very consistent with the Anne Arundel decision, because again, it's really all on the county, not the applicant, as far as any of these delays. So, again, that's what surprised me by the staff decision. So, thank you.
Commissioner Linton.
Thank you, Mr. Chairman. I had a couple of questions about the last page of staff's comments is on page 4, where you talk a little bit about the statute's directive that the commission conduct a meaningful study of the results of the pilot program. Our current regulations allow for the company to extend their application and the implementation of it for 6 months, and they've already proceeded with that. So they're asking, as they clarified this morning, for a couple of extra weeks. Could you describe what type of impact that will have on your ability to conduct the study?
Well,
if any?
It's 6 extra weeks, but here I'm really talking about why 18 months. I mean, you can say, well, why wasn't it 2 years, or why wasn't it without an end date? So it was we needed an end date in order to make sure that the projects that applied and were successful in getting interconnection were actually built. The 18 months, I think, is the furthest corner that it could be foreseen where things were under the applicant's control that we would want to get into, given that the period of the actual pilot is 3 years. In addition, let's see. Oh, I have the wrong one open. Page 4. Just give me a minute. See what I said? So the study should have as many of these projects in it as possible. They should be as diverse as possible. And of course, the clock is always ticking on that, and I'm told by Mr. Vanderheyden that he has some additional information for you that goes to your question.
I don't believe a 6-week extension would put us in a situation where we could not complete this study, given that a lot of the projects are not yet operating. There will not be as many. I don't think, as a matter of holding the objection is not because it would, keep the study from being conducted. Any project that is not operating as of now, and there are very few because of a lot of similar types of delays that have happened, we won't be available to study the operational aspect of it. We still will probably be able to look at some of the other details. I don't think the 6 weeks would create a significant problem. We would simply probably have to follow up or add additional data as new projects that were not incorporated in the initial study, we would have to update.
Thank you. You actually answered a couple of my questions in one, so thank you.
I would just comment on that too. This report has been very, one of those items that's very important to me, and I've expressed that several times when we've gone through these proceedings. And I was interested in the fact that you placed that. It was noted that we needed to have this meaningful report, and I talked with our legislative liaison, and he also confirms that very point, that it's not unusual, and of course we have an expert up here on the stand too, but it's not unusual to request extensions or to provide, additional reports, updated reports after initial report. So I think that I don't think we'd be in any violation of this requirement to have this meaningful report done with as many of the projects as possible. So I just wanted to.
Oh, you certainly have the right to wait.
Thank you, Ms. Garofalo. Based on this discussion, I find that the applicant has been diligent in pursuing this application, invested a lot of time and resources, and the delays have resulted from the county's lack of expediently moving some of these permits along. So in balancing the equities, I find that there's good cause that has been shown to extend the deadline to March 25th, 2019. I would ask that my fellow commissioners share where they stand. Commissioner Richard.
I agree.
Commissioner O'Donnell.
Mr. Chairman, I support that notion, but I want it to be very, very clear that that I don't consider this precedential, and I will consider future applications for extension on the merits and specifics of those cases. and certainly will not be persuaded that this has some bearing on future decisions.
Duly noted, and I agree with that sentiment. Commissioner Linton?
Thank you, Mr. Chairman. I also agree.
Commissioner Herman?
I agree as well.
Thank you. Is there a motion?
Yes, Mr. Chairman, I move that we grant the waiver of COMAR 2062-04C to extend the operational deadline applicable to the project until March 25th, 2019 for good cause shown, and direct the company to file a status report on the project within 45 days.
Thank you. Is there a second?
Second.
All in favor, say aye.
Aye.
Any opposed? The motion is granted.
Thank you very much.
Madam Secretary, the final item.
The final item on the agenda is Cypress Creek Renewables LLC, filed on July 17, 2018, request for extension of the operational deadline for completing its community solar generating system under COMAR 20.62.04C3B, pending resolution of a legal challenge.
So the applicable law in this one is the same as before. The difference is that in this case, the applicant truly has a pending legal challenge. It is described in the letter, but briefly stated with regard to the law, ordinarily an applicant would have to leave the queue within 18 months of application. However, under COMAR 2062-0304C3B, while it may be extended for 6 months, the applicant may also have his term extended if there is a pending legal challenge. In other words, something that is truly beyond his control. I think I have summarized in my comments what has gone on here, and we believe that under 2062, applicant would be entitled to a day-for-day extension for 6 months from August 14th, 2018, or until January 15th, 2019. However, applicant's attorney, who's here today, has said that it's possible the applicant will not be successful on appeal, and in which case, on appeal to the zoning board, in which case a judicial appeal would be sought. And however, staff believes it's possible that applicant will be successful on appeal and no further action will follow, and consequently the commission may wish to direct, in addition to granting the extension, the report from applicant by November 30th, 2018 on the status of the matter. And so I guess in summary, our recommendation on this one is that the commission direct Baltimore Gas and Electric Company to extend the deadline for Cypress Creek's completion of its Baltimore County project on a day-for-day basis under COMAR 20.62.03.04C3B to be due until applicant's legal challenge has ended, and direct the applicant to report to the commission on or about November 30th regarding the status of its pending legal challenge.
Thank you, Ms. Garofalo. Counsel for Cypress Creek.
Thank you, Mr. Chairman, members of the commission. My name is Christopher Mudd. I represent the applicant in this matter. We generally agree with staff's recommendation here. I do think that the COMAR provision is perhaps somewhat unclear, but I do think that our reading of it is the correct one, which would be that the day-for-day challenge is not subject to any limitation in timing. There was a suggestion in the report that it might be limited to a 6-month day-for-day because in any event, after 18 months, you would be booted from the system. I don't believe that's the way that it's read or to be read or to be interpreted. A little bit of color. We were successful before the zoning commissioner or the administrative law judge for Baltimore County in obtaining a special exception for this particular installation. It's on appeal by neighbors, now pending before the Board of Appeals for Baltimore County. We've been through one day of the hearing at the Board of Appeals, and we have 2 more days that are scheduled in late October. In regards to what the Board of Appeals may or will do, they're either going to approve it or deny it, and I anticipate in either event that an appeal would be taken to the circuit court. If we are successful, I firmly believe that the neighbors are motivated to appeal us to the courts, and if we are not successful, my client's motivated to appeal it to the courts. And as this commission may or may not be aware, that's looking at a lot longer than 6 months. And I believe that COMAR provides for that and contemplates that with the legal challenge provision. Also, I think there was some mention in the staff's report about whether or not, while on legal challenge, my client would be obligated to pay the fee to extend for the 6 months, and I don't think that that's part of what's intended either. Essentially, that could, in measuring equities, that would require my client to put forth about $100,000, maybe more. I don't have the exact amount, but without any assurance that they even have a project. So it's kind of it would be a penalty of sorts in order to do that. I think that pretty much explains where we are. The only other thing I'll mention as a matter of fact is that I'm likely not going to be the first person with this client to come from Baltimore County for this type of request, because there seems to be a siege against the industry in Baltimore County. I think in the rural parts of the county, there have been over a half dozen applications that have been filed. I think that maybe 1 or 2 of those applications have not been appealed, and the rest are on appeal. And there seems to be a coordinated attack amongst a lot. I'm using strong language here. I'm an advocate for my client, but there seems to be a coordinated effort by neighbors in that area to try and challenge these uses in rural areas. So I don't see that backing down, and I think that my situation is not going to be. In fact, I have another case for Cypress Creek pending on appeal as well. So I may be back for Cypress Creek on a different matter. Thank you.
Thank you. Questions for Mr. Mudd or staff counsel?
Real quick, Mr. Mudd, are any municipalities or government entities protesting these developments?
As a matter of fact, the People's Council for Baltimore County is involved in the appeal against my request, and I'm not sure if this commission is familiar with the People's Council for Baltimore County, but it's a chartered, established office and operates completely independently of staff. So, for example, the planning department and other agencies within the administration for Baltimore County were in support of our request through agency comments, and People's Council has independently taken it upon himself to participate in appeal. So I guess he's sort of quasi-judicial, he operates independently, but is involved against us in this particular case.
Okay, thank you.
Sure.
But he did not file in this matter here before the commission today?
Did not, correct.
All right, so today we only have the request before us to extend the time based on the legal appeal. That's what we will rule on. Seeing no further questions, is there a motion?
Yes, Mr. Chairman, I have a motion. Mr. Chairman, I move the commission grant the request to extend the deadline for Cypress Creek LLC's completion of its Baltimore County project on a day-to-day basis under COMAR 20.62.03.04.C3B until the applicant's legal challenge has ended, and further direct the application to report to the commission on or about November 30th, 2018 regarding the status of its pending legal challenge.
Thank you. Is there a second?
Second.
All in favor, say aye.
Aye.
The motion is approved.
Thank you.
Seeing no further business before the commission today, this meeting is adjourned.